Settle down. Court is now in session. This is a class action lawsuit filed against Max Jackson and Bob Dollar, two lawyers who allegedly provided negligent advice to employees of a Wisconsin-based company. Judge Brett J. Thomas presiding, that's me. Acting for the defendants is Mr. Brian Smith. Good afternoon, Brian.
Good afternoon, Your Honor.
I look forward to sharing a beer with you this evening, but I must pretend to be impartial for a short while.
That's quite all right.
Have you prepared an opening statement?
Yes, sir.
Let's hear it.
Your Honor, the only thing my client is guilty of is of not being guilty.
I concur wholeheartedly. However, we must maintain the illusion of due process. As much as it pains me, I will now proceed to receive the opening statement of the prosecuting attorney, Mr. James Willis.
Your Honor, this is a convoluted case of negligence made all the more complex by the sheer volume of claimants, the majority of whom reside outside the state of Texas. Now, with that in mind, I'd like to file a motion to transfer.
On what grounds, Mr. Willis?
It would promote the efficient administration of justice.
Denied.
Your Honor, may I ask why?
This hearing has already moved once from San Antonio to Austin. I will not entertain the request to move it again.
With respect, Your Honor, that was a change in venue. What I'm doing is I'm requesting a change in jurisdiction. Now, you must understand the legal significance of such a change.
I don't like your attitude, Sonny Jim. You're just the kind of hotshot that thinks he knows best, always correcting the judge on technicalities. I assume he went to Harvard Law.
That's Stanford Law, Your Honor.
They just proved my point.
I respectfully submit.
Denied.
Your Honor, please.
This case will continue to be heard in the state of Texas. I don't give a hell where the claimants are based. Mr. Willis, please proceed.
Your Honor, in the case of Johnson v. Johnson against Johnson v. Johnson, two attorneys cited opposite Johnson v. Johnson cases, and it was held that Johnson v. Johnson was overruled and Johnson v. Johnson was upheld.
That is a most peculiar precedent you're citing there.
Furthermore, in the case of Texas State v. Benny Lenny, it was held that Benny Lenny was not in contempt. He was not content with the judge.
And what does that have to do with this here session?
I submit that we throw out the case.
May I remind you that you are the prosecuting attorney? It does you no favors to throw this case out. Now please step aside and let the defense counsel demonstrate his superior intellect.
With respect, sir, in the case of Dallas Cowboys v. Green Bay Packers,
Young
it was
man,
decided...
I hope you're not citing football games to me now. I suggest you refer back to your papers. Son, where are your papers?
Your Honor, I respectfully submitted a ton of papers last night. Hope you got a chance to read them. I'll be the first to admit that, goddamn, that was a lot of papers, but I printed them off and I sent them to you in the post.
Where did you send the papers to?
I sent them to your house.
Why in the hell did you send them to my house?
I am sorry, Your Honor. I'm just trying to help.
You must have your own copy.
Well, that's the other thing. You see, there were so many pages that I didn't have enough resources to print off another copy, so that was the only one.
And it is currently in transit?
Yes, sir.
I can't quite believe what I'm hearing. Does the defense counsel have his own papers?
No, he has no defense. It's not true. I have my papers here. My client is not guilty. This poser thinks he can just come in from law school and bribe the judge by sending him papers in advance.
It takes more than some convenient pre-reading to buy this judge, let me tell you.
Don't I know it?
Mr. Smith, would you be so kind as to inform the court of the current condition of those beers?
Icy cold, Your Honor.
Just the way I like it.
Your Honor, may I interject?
Hush, hush now, boy. Now, just so I have this clear, there is at present a delivery driver halfway across the U.S. of A. trundling along to San Antonio with case files so extensive it has rendered your home printer obsolete. From San Antonio, it's another 2-hour drive to Austin. They're in a hope in hell that driver's going to have a hope in hell of getting those case files to you in the next 30 minutes. By which point, my thirst for pouring a bottle of suds down my gullet reaches tipping point. Without further ado, I will throw this case out. Is there any reason why I should proceed with this here case?
Your Honor, I've just received a text.
There will be no phones in my courtroom.
It's from the delivery driver. He's just arrived at your house.
How in the hell?
He's sending me my key arguments.
How very convenient.
Your Honor, I'm getting texts through at an alarming rate. Goddamn, he knows this case better than me.
Now, what is his motivation for familiarizing himself with the particulars of your case?
He's one of the witnesses, parked in your driveway, reading the case files.
Excuse me?
I know. I'll tell him to move.
Now, what did you say before that?
The witnesses, Your Honor, the delivery driver is one of them.
The driver you hired to send the court documents to my house today is a key witness.
That's right.
Now, what in hell does a delivery driver have to do with this case?
The delivery driver works for Green Bay Packers, the Wisconsin-based company.
Green Bay Packers is a football team.
It's also a logistics company, Your Honor. They package things.
That he is not here puts a great strain on the effective delivery of justice. I put you solely responsible if this here case gets thrown out. You never practice again. You probably practice again because you're a goddamn hotshot. But still, you'll learn a lesson. You learn more from this here case than you did 5 years of Harvard Law.
Stanford. Your Honor, this is highly irregular. Listen, the delivery driver has a vested interest in this class action against Max Jackson and Bob Dollar because it was their negligent advice that led to the entire workforce of Green Bay Packers losing their pension. And under various state and or federal laws, a delivery driver is deemed an employee and is entitled to draw from their pension when they reach retirement age of 95 years old. Your Honor, if I may.
Yes, Mr. Smith, please. This court could use a bit of sanity.
Thank you, Your Honor. I don't know about the legal significance of flipping a coin, but I do know about justice. And I can tell you that flipping a coin is the most justice thing there is. If you want to come down on the right side of justice, then flip a coin. Because there ain't not much in this world that's just. But I'll tell you one thing that is, and that's flipping a coin.
How very eloquently put, Mr. Smith. Now, what say we end this charade once and for all and have a couple of cold ones?
Your Honor, I object.
On what grounds?
According to my client, under Section 221 of the Convention Against Corruption, it is illegal in several states for the defense counsel to serve the judge an icy cold beer if he also intends to dismiss the case before the prosecution has a chance to set out their entire argument.
One of them states, Texas?
Yes, sir.
Well, ain't that quite the predicament? That there regulation applies pretty much exactly to this here set of circumstances.
Yes, sir.
Seems your epiphany has worked in your favor. Let the case proceed. God help us all. Brian, let's postpone until tomorrow, but buy a couple more crates. I'm gonna go absolutely wild.